You have the right to remain silent. Anything you say can and will be used against you in a court of law. If you've ever been taken into custody or simply watched a crime procedural on TV, you're familiar with the Miranda Warning, named after the 1966 Supreme Court case Miranda v. Arizona. However, if you're getting your legal advice from television, you may find yourself in serious legal trouble one day. Where does this right to remain silent come from? How is it protected? And just how constitutional is the Miranda decision? We'll discuss that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your and generation be free, and I'm so glad you could join me today. This is one of those episodes it's niggling at the back of my mind for a while about this idea of remaining silent and the Fifth Amendment constitutional protections, and I wanted to spend some time and get into that today. So I hope you'll enjoy it. I hope you'll also check out the website, constitutionstudy.com. I've got some good news, but I'll talk more about that at the end of the episode. But for now, let's talk about this right to remain silent. Almost every attorney I've talked to about the matter agrees you should not talk to law enforcement unless you've called them. You have a right to remain silent, and most attorneys recommend you avail yourself of that right. However, the reasoning behind that right, often seems to be misunderstood. When it comes to the right to remain silent, the most common mistake I hear people make is calling it the right against self-incrimination. However, a quick look at the Fifth Amendment shows that's not what it says. No person shall be compelled in any criminal case to be a witness against himself. The first thing we should notice is that this right is protected only in criminal cases. Whenever you are dealing with law enforcement, there is a possibility of criminal charges. This, I believe, is the basis for most attorneys generally telling people not to talk to law enforcement. The most important thing to remember, though, is that the Fifth Amendment does not protect you from self-incrimination, but from self-witness. Now, according to Webster's 1828 dictionary, witness is testimony, attestation of a fact or event. Yes, self-incrimination is a form of self-witness, but it is only one form of the right protected by the Fifth Amendment. Why is this distinction so important? Because of the impression it leaves. For example, a couple of years ago, 2 FBI agents came to my front door to deliver a subpoena. Now, after giving me the pertinent details, one agent started asking me about my farm. I told him that I do not get chatty with law enforcement. In a way, I was invoking my right to remain silent by not discussing a topic other than the legal duty they were performing, the deliverance of a subpoena. Now, my actions could be taken in 2 ways. If I was invoking a right against self-incrimination, the obvious conclusion would be that I was guilty of something and did not want to incriminate myself. If, however, I was invoking a right against self-witness, that I did not want to attest to facts related to my farm. In the former, I was guilty in trying to avoid being caught. However, the latter was simply me not wishing to divulge information to law enforcement for whatever reason I deemed fit. While often misrepresented and even misused, this right protected by the Fifth Amendment led to the famous case Miranda v. Arizona. On March 13, 1963, petitioner Ernesto Miranda was arrested at his home and taken in custody to a Phoenix police station. He was identified there by the complaining witness. The police then took him to interrogation room number 2 of the Detectives Bureau. There he was questioned by 2 police officers. The officers admitted at trial that Miranda was not advised that he had a right to have an attorney present. So Ernesto Miranda was an indigent Mexican and, according to the court, seriously disturbed. After being arrested and identified, Mr. Miranda was interrogated. The 2 interrogating officers admitted that Mr. Miranda had not been advised that he had a right to an attorney. 2 hours later, the officers emerged from the interrogation room with a written confession signed by Miranda. At the top of the statement was a typed paragraph stating that the confession was made voluntarily, without threats or promises of immunity, and with the full knowledge of my legal rights, understanding any statement I make may be used against me. Whoops. See, the form upon which Mr. Miranda had written his confession had a statement that was not true. Mr. Miranda did not have full knowledge of his legal rights, nor did he understand that his statements could be used against him. Well, all of his statements. Now, one could assume that this written confession could be used against him, but did that include anything else he said during the arrest and interrogation? At his trial, Mr. Miranda's attorney objected to the confessions, both oral and written, being entered into evidence. However, these confessions were entered into evidence, and Mr. Miranda was found guilty of kidnapping and rape and sentenced to 20 to 30 years in prison for each count. Upon appeal, the Supreme Court of Arizona upheld the conviction. In the opinion of the Supreme Court of Arizona, Mr. Miranda's rights were not violated because he never asked for an attorney. The Supreme Court of the United States, however, reversed. From the testimony of the officers and by the admission of respondents, it is clear that Mr. Miranda was not in any way apprised of his right to consult with an attorney and to have one present during the interrogation, nor was his right not to be compelled to incriminate himself effectively protected in any other manner. Without these warnings, the statements were inadmissible. The mere fact that he signed a statement which contained a typed-in clause stating that he had full knowledge of his legal rights does not approach the knowing and intelligent waiver required to relinquish constitutional rights. According to both officers and the state of Arizona, Mr. Miranda was never apprised of his right to an attorney. The Supreme Court did get one thing wrong, though. The Fifth Amendment does not protect Mr. Miranda's rights against self-incrimination, as the court states, but his right against self-witness, as I've pointed out. How could Mr. Miranda attest in the confession that he had full knowledge of his rights if he had never been advised of them? Not everyone agreed with the court's opinion. Justice Clark, in his dissent, joined by Justices Stewart and White, stated that he would have upheld Mr. Miranda's conviction. These confessions were obtained during a brief daytime questioning conducted by two officers and unmarked by any of the traditional indicia of coercion. I don't know if I would call a 2-hour interrogation brief, and I doubt Mr. Miranda would. While there was no evidence of coercion, there is more to Justice Clark's reasoning behind his dissent. They assured a conviction for a brutal and unsettling crime for which the police had and quite possibly could obtain little evidence other than the victim's identification, evidence which is frequently unreliable. There was, in sum, a legitimate purpose, no perceptible unfairness, and certainly little risk of injustice in the interrogation. Yet the resulting confessions and the responsible course of police practice they represent are to be sacrificed to the court's own fine-spun conception of fairness, which I seriously doubt is shared by many thinking citizens of this country. Let me get this straight. This officer of the court, this so-called justice, believes that obtaining a confession for a crime by violating the rights of the accused is acceptable because the crime is brutal and the police have little evidence. Are the courts more interested in convictions than that the convicted is the guilty party? When Mr. Miranda signed the confession stating he had full knowledge of his legal rights, that was apparently an unintentionally false statement. Remember, Mr. Miranda was an indigent Mexican. How is he supposed to know how his rights were protected by the Constitution of the United States? Furthermore, Justice Clark appears to blame the court for this problem. This ignores the fact that these two officers had most likely used this form many times and should know that it requires a signer to be in full knowledge of their rights. Why is it the responsibility of the accused to know what he or she does not know rather than the professional officers representing the government? It seems Justice Clark has forgotten the most fundamental rule in American jurisprudence. People are innocent until proven guilty. Now, as I had mentioned, though, Justices Clark, Stewart, and White were dissenting. The Miranda case actually included multiple cases from different courts. That's why the opinion of the court in Miranda v. Arizona was, therefore, in accordance with the foregoing, the judgments of the Supreme Court of Arizona, of the New York Court of Appeals, and of the Court of Appeals for the Ninth Circuit are reversed. The judgment of the Supreme Court of California is affirmed. Why do I make such a distinction between self-witness and self-incrimination? As I've already shown, it starts with the presumption people have when you exercise the right. For example, during the trial in the case of Wisconsin versus Kyle Rittenhouse, Assistant District Attorney Thomas Binger twice commented on Mr. Rittenhouse's decision to remain silent after the shooting. Both times, he was apparently attempting to instill in the minds of the jury members that Mr. Rittenhouse's silence was an admission of guilt. Both times, the judge had the jury removed from the courtroom to scold Mr. Binger. How many times have you seen actors portraying law enforcement officers claim, "If you have nothing to hide, why not talk to me?" That is a blatant use of someone's right against self-witness being considered self-incrimination. According to attorneys I've talked to, this practice is not unique to television and is, in fact, widely used by law enforcement today. This right to remain silent is an excellent example of why John Jay's admonition is so important. Every member of the state ought diligently to read and to study the Constitution of his country and teach the rising generation to be free. By knowing their rights, they will sooner perceive when they are violated and be the better prepared to defend and assert them. By knowing your rights, including your right against self-witness, you will be better prepared should you one day encounter law enforcement. When I told the FBI agent that I did not get chatty with law enforcement, he told me he understood, and both agents returned to their vehicle and left. Thankfully, that's as far as it went. But I was prepared if the FBI tried to push for more. Some of the best advice I have received from attorneys is to keep my mouth shut. I've been told repeatedly to identify myself, potentially provide needed information regarding others, then inform law enforcement that I am invoking my right to remain silent and shut my mouth. No matter what the officer says, claims, or threatens, I'm supposed to keep my mouth shut until I've consulted with my attorney. I believe that is advice you should follow as well. Remember, anything you say not only can, but will be used against you. I found a YouTube channel of an attorney. He works with a certain class of cases in a certain state, but one of the things he does is he takes a body cam video and he analyzes how the defendant responded. And the most common thing they get wrong is they talk. Do not talk to police. Now, I'm not trying to make it an adversarial situation. If you call the police, talk to them. In the situation when the FBI showed up, we had a pleasant conversation about the duty at hand, the delivering of the subpoena. But I didn't let the conversation stray anywhere else. It should be the same pretty much everywhere you are, because no matter what the situation, whatever you say in front of law enforcement can be used against you. Even if you didn't say anything wrong, it can easily be interpreted as an admission of guilt, or at least opening an investigation. You just don't want to do that. But I want to focus on this idea of self-witness, not self-incrimination, because that's where I see a lot of people get caught up. Well, if I did nothing wrong, why shouldn't I talk to the police? Remember, police are there to investigate a crime. They're there to find someone to charge with the crime. They aren't your best buddies. They aren't there to help you. They're there to investigate whatever they're investigating. And we need to remember that. Now, I have great relationships with my county sheriff and with a few of his deputies. And I have no problem if I witness something happen, if I witness a crime, telling them what I saw, identifying individuals who I believe committed said crime. But I'm not going to talk about myself. Again, I'm not a lawyer. Take this with a grain of salt. Consult your own attorney. But that's why I focus on what the Constitution actually says. You have a right to not be a witness against yourself in any potential criminal proceedings. And I think it's something we should exercise. Now, I mentioned I have some news about the Constitution study. I finally got the Patriots program up and running. The boot camp's been running for a few months, but the actual program, the membership that you join is now working. It's still in its infancy. We're still building content, but it's there. So if you want to find out more, go to constitutionstudy.com/patriots. You can find out more about the program. Take the boot camp. If you pass the boot camp and agree to the little oath we have, then you can join the Patriots. We've got some great ideas. There's some great things that we're working on, and I hope you'll join us. I also hope you come back here and join us here the next time for the Constitution study.
Love the neighbors and have a few good friends.